And welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast around the world on CRNTalk.com, also on Roku, Tiki Live, and of course on Facebook.com/CRN Talk. I'm joined as always by the one and the only, an active attorney, U.S. Army veteran, a Juris Doctorate in law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, American Illusion of Freedom, is available on Amazon.com, Barnes & Noble, and on iTunes. Ladies and gentlemen, Mr. Richard Nixon, and the show that gives you the news you get nowhere else. How are you, Richard?
It sure does. I thank you very much, Mike. Of course, like many of us, I'm crestfallen at the results of the New York versus Trump case, the 34 convictions. I would be upset if there were one conviction. However, what's interesting is just happens to be in the Daily Journal, recent, let's see what the date is. I'm sorry here. May 29th on the first page on the right, above the fold, it says, L.A. County Judge sanctioned for texting prosecutor during murder trial. And just to sum it up, L.A. County Judge was given public censure, which is the harshest punishment allowed short of removal from the bench for texting a prosecutor about a murder trial and then trying to minimize her conduct once she was caught. And just in summary, what it says here is she attempted to put a thumb on the scales of justice, crossed the line from an impartial judicial officer to an advocate, and displayed neither neutrality nor wisdom. Now, if that doesn't remind one of the New York versus Trump case and Judge Mersham, I don't know what does.
Yeah, Judge Mershon, of course, it was recently revealed, too, that he has donated to a political action committee that was anti-Trump. Of course, his conduct from the bench with the gag order, with multiple thousands of dollars of fines levied towards President Trump for expressing himself, and also admonishing some of Trump's defense witnesses, clearing the courtroom and pretty much, almost getting in verbal conflicts with them. Seems a little bit crazy. Of course, we're talking about the big news of the week that former President Trump was convicted 34 counts. The 34 counts, of course, of falsifying business records under New York Penal Law Section 175-10, a Class E felony. So, of course, we're going to be discussing that because it's been this decision, at least among conservative media, has been widely condemned.
Yes, and you know what I find interesting is the parallel between Mr. Trump and Judge Mersham. Is they're probably of same disposition. They talk, both of them talk too much and drive people away from them because of all the things they say and do and so on. And neither one will shut up. I don't know whether that can explain the behavior, the poor behavior of the judge, but I think a good appeals court panel will put him where he belongs.
We're going to talk about some of the remedies moving forward for former President Trump and some of the consequences of this pretty much historic verdict that was reached earlier this week. And if you want to know more about this fantastic show, you can always find past and previous sessions available on YouTube or also on Rumble. Find CRN Digital Talk on both those platforms. Also, we're a podcast at crntalk.com/podcaster. And once again, check out Richard's fantastic book, America, An Illusion of Freedom, available wherever fine books are sold. And let's stick around. We'll be right back. And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Of course, talking about the historic news of the week, maybe of the campaign that former President Trump found guilty on 34 counts of falsifying business records, and that becomes a Class E felony if it's in furtherance of a crime. And what's interesting is that in both the statement of facts that prosecutor Alvin Bragg put out in the indictment itself, they never outlined a specific code section of what the furtherance of that crime was. I think they ambiguously pretty much said campaign finance violations. More of that later. But of course, the ramifications of this are immense. I just saw, Richard, on the way over here that felons are not allowed in 36 foreign countries. So, I mean, I don't know how President Trump, if he's reelected, how he would actually be able to execute his duties. Before we get into why some say that these convictions are unconstitutional, Richard, I want to ask you about some of the like I said, the ramifications of this verdict. I mean, how does the man now, President Trump, that is, how does he campaign? And if he is reelected, how does he govern?
Well, that's right, because nothing will have been solved unless we, and I've heard other people mention this on television, that there is a remedy that can be used almost immediately, and it's called the common law writ. Now, we all know about the writ of certiorari. That's when you send a document to the court, Supreme Court, and ask that it hear the case now because of certain sensitivity or some type of emergency situation. However, there is a thing called a common law writ, which means, I know this is lawyer talk here, but it basically means we kind of put the rules away temporarily because, Mike, you found out that there can be no appeal until sentencing, which is, of course, why I think the judge put the sentencing off quite a bit to stop Mr. Trump from appealing as soon as he could. But anyway, there are things called equitable remedies, and what they are judicial remedies developed by the courts of equity from about the time of Henry VIII.
Friend of the show.
Right. To provide more flexible responses to changing social conditions than was possible in the precedent-based common law. And basically, what you've got is a situation where the law doesn't seem to fit the situation. And so you go to the court and ask for a common law writ. And a good example would be, what do we do with Mr. Trump now? If he is convicted and if he's sentenced to jail, what do we do? Only one problem here is, what do we do? Do we lock him up? And do the Secret Service people go with him? Do we lock him up at Mar-a-Lago? And as you said, Mike, what about his traveling to foreign countries while he's campaigning? Can he not do that? He won't be able to vote, and so on. And again, this all goes back to my original article, which I sent to the Daily Journal, which was not published, that Mr. Trump and any president should enjoy total immunity after they leave office. Their only punishment, if you will, is to get him while he's in the office, impeach him, send that impeachment to the Senate, and have the Senate by 2/3 vote remove him, and that's it.
Of course, the immunity that you're talking about here, this sovereign immunity, that's for acts while he was president.
Yes.
Not before, not after. And he did write this check to Stormy Daniels while he was president. So that should be covered under presidential immunity. And it should be noted, too, that, Richard, in the January 6th case, we're waiting to hear the Supreme Court deliver their opinion on whether or not he does enjoy immunity.
Absolutely.
And so interesting. I wonder if the Supreme Court does rule that he does enjoy immunity, will this case then be dead? Because this is a state case, though. So I'm confused on whether or not presidential immunity would apply to both federal and state cases.
Exactly. And that's, again, why we talk about common law writs, because they're not limited to the remedies that the law would provide. The judges can make any remedy they want. They can say, and this ruling extends to so-and-so case or to state cases, or they can modify. Again, it goes to a situation basically where the law doesn't seem to fit the situation in order to do justice for the defendant. And that's as close as we'll come to it. And I think this case clearly qualifies because if for nothing else, it's totally unique that we're carrying a president this far in prosecuting him.
Going back to equitable remedy, equity is said to operate on the conscience of the defendant. So an equitable remedy is always directed at a particular person, and that person's knowledge, state of mind, and motives may be relevant to whether a remedy should be granted or not. And speaking of the language here, motives, what was the motive here? I mean, President Trump's contention was that he paid this money to Stormy Daniels to save himself the embarrassment of this affair becoming public to his family.
Right.
If he was already president when he wrote these checks to Stormy Daniels, what is the motive? Because he was already president, and Mr. Bragg says that
that's correct.
The furtherance of the crime was that it defrauded the voters. He was already president.
Right. And again, they say, well, because he wouldn't reveal this stuff, he was paying off these ladies, I use that term loosely, for not revealing what he had done as a bad boy. Again, as you say, it was after the fact. He was already president, so how could that hurt anything except if he was doing it to save embarrassment with his wife and family? And that is, again, what Mr. Trump has been arguing all the time. However, we must remember, in the New York versus Trump case, it didn't matter what the law was. They were going to, that is, New York was going to convict this guy on every one of, was it 43 or 34 counts?
34 counts.
34 counts. No matter what the facts were. In other words, as some people have said, don't bother me with the facts. This is how I'm going to rule. And that's exactly what they did.
That was the most interesting thing to me. I was shocked because, I mean, you and I have been talking about this case for quite some time,
yes.
And I still don't pretty much understand the half of it. And for this jury to decide all these 34 counts as guilty in what was it, like 11 hours of total deliberation?
Right.
That's kind of unprecedented.
Yeah. And in fact, I wondered why the prosecutor and the judge in that case would have even allowed two, quote, informed lawyers to be on the jury panel. I figured, that's stupid. That's a pro-defendant position there to allow two attorneys on there because they will, if no one else does, write the rest of the, if you will, non-lawyer participants in the jury, and so we should get something close to what the law really is. But in fact, apparently those two jurors, those lawyers, they went the same old way, I guess, because politics was stronger than the law.
Well, and because also they have, just it's human dynamics, human nature, small group dynamics, that you're going to look towards those who have so-called expertise.
Yes.
And so if in the jury deliberation room, we have two attorneys saying, I know the law, I know what's what here, and you're not an attorney. I mean, like, I defer to you a lot of stuff on legal stuff because you're the attorney and I'm not. So of course I'm going to follow your lead, just as these other juries followed those other two attorneys' leads.
And now that you mention that, I was on a jury some time ago. And we were in the jury box, and every now and then, one of the people there would say, well, Mr. Nixon, what do you think about that? I would tell him, and then again, I would say that you got to make up your own mind, but this is what I think about so-and-so. And sure enough, they basically went along with what I said.
Interesting enough. So we're going to talk more about this. We're going to talk about an interesting argument about perhaps this case will be mooted on appeal because of First Amendment grounds. Stick around. We'll be right back right after the break. Stay with us. And we are back in the Legal Lounge. Once again, thank you so much for joining us here. We really appreciate it, whether or not you're watching live or after the fact on YouTube, on Rumble, or on Facebook. We appreciate it. And, of course, we're talking about the historic news of the week of the conviction of Donald Trump, 34 counts of falsification of business records, a Class E felony. And the only reason that this is a felony and also survives the statute of limitations because, according to this statute, it's furtherance of a crime. And that furtherance of the crime, according to Alvin Bragg, was campaign finance violations. But also there's now a very interesting First Amendment challenge perhaps brewing to this. Richard, please explain.
Well, this is what, and I've struggled with this too, but I don't know if I gave this hypo over the air last week or not, but there is such a thing as common law burglary that we all learned in law school. And basically it says that the breaking and entering of a dwelling at night with the intent to commit a felony is a violation of so-and-so code. Now, that situation there is not enough because we don't know what the felony is. So in order to convict a person under that code section, we have to also include the felony that he's alleged to have done is burglary, murder, rape, arson, whatever. Now, with those two, we can now proceed against this particular defendant. Well, this is exactly what was happening in this case, in Mr. Trump's case. And as the article from Reason says, President Donald Trump was convicted yesterday of allegedly altering business records to conceal his alleged payment of money to a porn star, Stormy Daniels, in order to influence the 2016 presidential election. Now, altering business records under New York state law is only a crime if it is done to conceal the violation of some other law. So there is the comparison between what I mentioned, common law burglary, and this situation. Now, Manhattan District Attorney Alvin Bragg alleged that the documents were allegedly falsely altered to conceal a contribution of money in violation of federal campaign laws or in pursuance of winning the 2016 election by defrauding the voters of information they had a right to know. Neither argument passes First Amendment scrutiny. So again, Mr. Trump had every right to do what he did, and putting these two together to come up with one felony, in this case 34 felonies, just doesn't hold water.
In 2010, of course, Citizens United versus the federal FEC, otherwise just as colloquially known as the Citizens United case, Supreme Court held 5-4 that a freedom of speech clause in the First Amendment prohibits the government from restricting independent expenditures from political campaigns by closely allied corporations and groups like the Trump Organization. Under Citizens United, it was perfectly legal for the Trump Organization to pay Daniels $130K in hush money to conceal her alleged affair with Donald Trump. Also, Alvin Bragg's argument that Trump defrauded American voters by preventing them from hearing about Trump's affair with Stormy Daniels, that voters had no right to know about Donald Trump's sex life, he obviously not being monogamous to his third wife, and voters who adhere to traditional values voted for him anyways because of his Supreme Court picks. What you read and said in that first paragraph, too, about that Alvin Bragg alleged that documents were allegedly falsely altered to conceal a contribution of money in violation of federal campaign finance laws. What does the DA of Manhattan, Alvin Bragg, have to do with federal crimes?
Well, that's right. That's just another one. The other thing, too, is this. Apparently, there was no errors in the bookkeeping. The checks that he wrote, the $3,500 checks that he wrote, one after another, were absolutely 1,000% consistent with the bookkeeping that was done in that account. So there was no, the first part of the syllogism, if you will, wasn't there. And the other thing that's kind of interesting as a practical matter is that the opinion in Citizens United was written by former Justice and liberal icon Anthony Kennedy, and it was joined by Chief Justice John Roberts, Justice Clarence Thomas, and Justice Sam Alito, all three of whom are still on the Supreme Court. And given the court's current membership, it's highly likely that the outcome in Citizens would prevail again today by a 6-3 vote. And as we said, all it takes is for that Supreme Court assemblage to recognize the so-called common law writ and get her done, who knows, maybe by Monday.
You never know. And just as a postscript here to this article, I think this language is important. The Roman Republic fell when politicians began criminalizing politics. We are gravely worried that we are seeing the pattern repeat itself in present-day United States. It is quite simply wrong to criminalize political differences.
Yes, and it's so important that we have other people fighting back. That's the interesting thing. If you can be paid to do wrong, it's very tempting to do wrong. And that's how I see the Biden administration versus the Trump administration. It makes more sense, if you will, political sense and also financial sense to cave into the Chinese, the Russians, the North Koreans, and so on. And being good is very difficult, but it's the right way.
Indeed it is. Stick around. We'll be right back right after the break. Stay with us. And we are back in the Legal Lounge. Once again, thank you so much for joining us here. Make sure to check out Rich's fantastic book, American Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And of course, we're speaking about the historic news this week. Former President Trump, that is, convicted 34 counts of a Class E felony in the state of New York. And Jacob Solom, who's a well-known attorney, litigator, and constitutional scholar, he's written about this extensively, and he says that the prosecution's story featured several logical and possibly claims. Last January, Manhattan District Attorney Alvin Bragg summed up his case against Donald Trump this way: "We allege falsification of business records to the end of keeping information away from the electorate. It's an election interference case." And I should note, Richard, that the Department of Justice actually did not agree with Mr. Bragg, because they looked into these same allegations and said that there was no case here. The gloss made no sense because the records at the center of this case, 11 invoices, 11 checks, and 12 ledger entries that allegedly were aimed at disguising a hush money reimbursement as payment for legal services, were produced after the 2016 presidential election. At that point, Michael Cohen, a known liar, Michael Cohen, I should add, Trump's lawyer, had already paid porn star Stormy Daniels $130K to keep her from talking about her alleged 2006 tryst with Trump, and Trump had already been elected. The prosecution's case against Trump, which a jury found persuasive enough to convict him of, was peppered with temporal puzzles like that one.
Absolutely. And then you also had the New York Times that got involved, and the editorial's characterization of Cohen's payment to Daniels is confounding for a similar reason. A payoff like this is not illegal in itself, the Times concedes. What makes it illegal is doctoring business records to mask its true purpose, which prosecutors said was to hide the story from the American people to help Mr. Trump get elected. However, again, the so-called doctoring of business records happened in 2017. Contrary to what the Times claims, it did not retroactively make the Daniels payment illegal.
Also, since the juries were instructed that they did not need to settle on any particular theory, it's not clear that how they unanimously accepted the idea that Trump committed crimes in hiding pertinent information about himself from the American people. Also, Richard, we talked about this on the phone yesterday, that this is in New York.
Right.
Donald Trump was from New York. Donald Trump is a New York legend.
Right.
Everybody in New York, if not the entire country, if not the world, knows that Donald Trump was, a man about town. He's publicly been, he's been married 3 times. It famously was in the tabloids all the time with the whole Marla Maples thing. I mean, he didn't conceal this from the public for electoral purposes because everybody knew that Trump was
And you know what? A poor guy that's that wealthy, he is a chick magnet all the way. He's going to be meeting babes every day, 10 times a day, and it's impossible if the guy hasn't.
Yeah, it's like drinking from a fire hose over here. Yeah, I mean, let the man live. But also this whole thing about concealing information from the American public that they should know about his election. Well, first of all, he's already elected. But secondly, Franklin Delano Roosevelt was in a wheelchair the entire time he was president, and he concealed that from the American public.
Absolutely.
John F. Kennedy had Addison's disease and had a pretty much destroyed back, and he kept that from the American public for years.
And he was a womanizer all the way.
Oh, yeah. I mean, him and Trump could probably, go 1 for 1 on that. And the politicians keep stuff from the public all the time.
Yes.
This seems like selective prosecution to me.
Absolutely. And again, according to another theory of so-called unlawful means, Trump facilitated a violation of New York tax law by allowing Cohen to falsely report his reimbursement as income. But since Cohen filed those allegedly fraudulent tax returns in 2018, after Trump had been president for more than a year, his misrepresentation could not possibly have helped Trump with the election. So it goes on. And you're forced to conclude with all these facts that the jury had made up its mind, not only once it was seated, but probably 4 years before it was even selected for jury service. This was a fixed or rigged jury, and I'm sorry, but to say, as an attorney, I am actually ashamed that lawyers and judges were involved in this rigging.
But not to, necessarily kick a man while he's down, that man being former President Trump. if Trump had been willing to concede some of the prosecution's allegations, vis-a-vis he had the affair with Stormy Daniels, his lawyers could have focused on the shaky legal argument for charging him with felonies, right?
Well, yes, but see what you're doing. You have to deny this because of your wife. You can't admit this stuff to your wife. Now, of course, maybe she knows that he did it and is allowing him to deny it. And then he is, I'm sure he's getting some legal advice saying you're better off if you deny. Who knows what went on behind closed doors there. But again, I think if the attorneys on the jury, there were two of them apparently, if they had paid attention to the law, as we have just pointed out here in our fantastic show, Trump would have been found not guilty.
Also,
on all 34 counts.
All 34 counts indeed. And also, he's in a unique situation because he is the Republican nominee and
Yes.
quite possibly the front runner to become president in 2024. And so, President Trump, as we know, he's got kind of an irascible personality. And he's probably not going to be susceptible to kind of the lawyerly client control that most people are because he knows he's running for president.
Not only that, but you see, unless the court, as we mentioned earlier, the so-called common law writ, unless the court gets involved before this upcoming election, you're going to see Mr. Trump, if he does make it, and I think he will become our next president again, he will be harassed from day one, calling him a felon and so on. And the Supreme Court does have the authority under a common law writ to stop that kind of name calling and to prevent anyone from taking any action against him unless it's for impeachment, which I know he can beat.
Yeah.
But my point is, it's not going to end unless the Supreme Court takes a step now to reverse everything.
And do you think, we got about 30 seconds left, do you think that the Supreme Court's going to step in on this?
I do, because Mark Levin has mentioned it as well as, of course, as I have. But that idea is growing, and I think it could happen that the Supreme Court gets involved.
Very similar to what happened in the Colorado case.
Exactly.
Where the Supreme Court pretty much said, hey, you can't have one state decide the election for the entire country.
Thank you for remembering or reminding me of that. That's exactly what you've got here. You've got one state, one city, one prosecutor, and one judge literally, conceivably, determining the 2024 election and just how battered Mr. Trump will be if he runs.
Stick around, guys. We'll be right back right after the break. Stay with us. And we're back in the Legal Lounge. Once again, thank you so much for joining us here. So let's see what Mr. Trump's options are here, Richard. We talked about before that he said he will appeal and will appeal vigorously to the highest court of the land if necessary. And as we mentioned before, he cannot formally appeal this conviction until sentencing, which I believe is July 7th. Which I should add parenthetically is, I believe, 3 days before the Republican convention begins. And Richard, and just to debunk a couple things out here, I've been seeing on social media that Mr. Trump will not be able to vote as a felon. That is actually not the case because he was convicted of a felony in New York, and his place of residence is in Florida. So in order for him to be disenfranchised in Florida, he must be convicted of a felony in Florida. And Ron DeSantis came out and pretty much said that this morning.
Interesting.
One thing, though, that is interesting, Richard, that maybe we'll talk about, because we've talked about Brune a lot, is that he is now unable to possess a firearm in the state of New York. And so perhaps he'll maybe join some of the cases that we've covered regarding that issue vis-a-vis Brune. But anyways, let's move on and circle back to this equitable remedy. And these writs that you talked about. Can you expand on that a little bit more?
Yes, thank you. We did talk about common law writs, and we didn't really define what they are. Basically, they're part of what are called equitable remedies. And something you provided for us, Mike, here says from Wikipedia, equitable remedies are judicial remedies developed by courts of equity. Another word for equity is more or less fairness. From about the time of Henry VIII. Is he the one that had 7 or 8 wives that he killed?
The 6 wives of Henry VIII. That's correct.
Okay. To provide more flexible responses to changing social conditions than was possible in precedent-based common law. Now, equitable remedies were granted by the Court of Chancery in England and remain available today in most common law jurisdictions. Notably, the United States Constitution's 7th Amendment preserves the right to a jury trial in civil cases over $20 to cases at common law. So they're still viable. Now, what that means is this. You had just mentioned that no appeal could be taken until the sentencing in Mr. Trump's case, and that might be a reason for why they delayed the sentencing, so that he could not bring his appeal till a much later date. However, the so-called common law writ throws all of that aside. Those are all legal rules, if you will, law. Equity has to do with the whole idea that we have a situation here that's simply maybe not heard of before. It's simply not fair.
Unprecedented.
Unprecedented is a good word, absolutely. And there's every reason to believe, and I've heard the great Mark Levin mention this as well, we can jump, that is to say, Trump can jump right into the Supreme Court almost immediately under a so-called common law writ, and it doesn't matter what the law really is, and we can argue just what you said there, Mike, that what's he supposed to do as a nominee, looks like the nominee of the Republican Party, is he going to have to live with the limitations on his ability to go to foreign countries and campaign and so on? What's going to happen if he goes to prison? What happens to the Secret Service? Are they going to be tailing along with him, carrying guns? It presents an awful lot of things, and it's further. This whole thing of his convictions, convicting a former president of any felony or any misdemeanor, goes strictly to the argument I made earlier in earlier weeks that the president should be absolutely, totally immune while he's in office and even after his office. And the only remedy you have for the president is that he's no longer president. Because he's been convicted and impeached. So I believe we have to live with the fact, I know some people have said, well, that means that the president can do anything wrong that he wanted to do and while he's president, and so he gets removed by the Senate, and now what? Now he's free to do what he wants? Yes. And the rationale for that and the reasoning for that is the
Impeachment judgment clause.
well, impeachment judgment clause, but I'm thinking of second, convicted twice for the same
Double jeopardy.
Double jeopardy. Thank you. We have to live with that, and who comes to mind is Juice. We think that many of us think that he did kill his wife and her paramour, but he was found not guilty. And if he, while he was living, if he took the stand or did anything, made a publication or a book that said, "Ha ha, I did it," it's too bad. We believe more strongly that a person should not be harassed once he's gone through the court system and been either convicted or exonerated. We can't do it again. And the same thing should be true for a president. Once he's been in, he should not be harassed, because he won't be able to do his job as president if he's always considering, what can they do to me once I leave office? That is not the kind of president you want. You want a president that's bold and able to do exactly what he wants, similar to the speech and debate clause in Congress. Those guys, those congressmen, they have a right to say whatever they want without being prosecuted. Their First Amendment rights are just greatly expanded.
And one of the reasons the speech and the debate clause came into order in the Congress is because they were worried that if, I'm a senator and I says, hey, from California, and said that the people over here in Nevada are doing something wrong, they don't want, if I go to Las Vegas, for Nevada to arrest me, which is almost very similar to what happened to President Trump. Stick around, you guys. We'll wrap things up here right after the break. Stay with us. And we're back in the Legal Lounge, wrapping things up. Once again, thank you so much. Of course, we're going to be following all the legal developments concerning Mr. Trump's conviction moving forward, appeals, sentencing, whatnots. And so we wanted to end things something with a little bit lighter here. This is something that referred to as trail immunity. And I want to preface this is that you can have trail immunity, but you can't have tree immunity. Richard, explain.
Okay, the article is written by Mr. Rubenstein, Michael Rubenstein. It's in the Daily Journal, and it says, trail immunity is the condition and integral part of the trail. That's a good title. Looking forward to an evening of recreation at Diaz Lake, a couple parks their car and begins to walk down the trail towards the water's edge. Just as they step foot onto the trail, one of them tumbles over a hard-to-see wire tied to two wooden posts. The wire and posts are used as a boundary to delineate the beginning of the trail and to keep cars out. The man is injured and he files suit. However, he met the Government Code Section 831.4, which immunizes public entities for injuries suffered on any trail connected to outdoor recreation areas. And that's what the court held in this case called Helm versus City of LA. And I'll read the rationale for why the court immunizes the government for that. The paramount purpose for trail immunity is to keep outdoor recreational areas open to the public by preventing burdens and costs on the entities that maintain them. Public policy favors absolute immunity for government entities as an incentive to open their properties for public recreational use. Trail immunity applies to both paved and unpaved trails, as well as to many bicycle paths. And for example, in a case called Farnham versus the City of LA, that trail immunity applied when a bicyclist was injured on the paved bike path in Balboa Park. There's more to say there, Mike, if you'd like to continue.
No, I like this. I personally like this, and I would like to see this immunity actually go towards other property, and I'll tell you why. Other public property, I'll tell you why. Growing up, I lived across the street from an elementary school, and I went to that elementary school, and we used to go and be able to play in the playground on the basketball courts after school and on the weekends. And then one day they put a padlock on the whole school around. And we're like, you know, why? I live across the street. I went to this school, an alumni. Can I come over here and shoot baskets every once in a while? And the custodian said, no, you can't, because if you get hurt, you can sue us. And that was terrible. I mean, I love shooting baskets, and
That's right.
And I would like to see more of this. And it's of course you don't want to have Runyon Canyon closed because someone sues because they tripped.
Right.
And so I like this decision.
Well, that's right. It reminds me of Balboa Park. We used to do the similar thing where you run around Victory and Burbank and so on. There's a golf course there and a nice trail, and people are using it, but every now and then somebody would get hit with a golf ball. And so they put up some signs, not for personal use and so on. And then as a lawyer, I said, that's not smart, because what they should do is let the people use it. And then if someone gets hurt, you got the 831.4. And that's what they've done. Now it's open to the public. And if you get hurt there, it's tough.
Yeah, I mean, it's personal responsibility. I mean, you should put a sign up that says, like, warning, you might get hit with a golf ball, and just keep your head in a swivel.
That's exactly right.
Richard, we're out of time. Thank you very much.
Thank you very much.
And thank you to all those listening, watching either live or after the fact. We are on YouTube. We are on Rumble. Find CRN Digital Talk Radio on both those platforms. And keep your head up out there, everybody out there. Who's the country is not fallen yet. We shall see what has moving forward. Once again, thank you so much for joining us here in the Legal Lounge, and we'll see you guys next week once again in the aforementioned Legal Lounge. Take care, folks.